Like we're recording live. Our court reporter for today, my name is James Robert Redford. I'm the Court of Claims Judge assigned in the matters of 20-094 NM et al. And today is the day we've set for hearings. There are 4 individuals present in the courtroom in addition to Mr. Cranmer and Ms. Husa, the court's legal counsel and law clerk, and appreciate everybody being here. There are a number of folks on the lines, as they say, or on the internet. We'll go through the batting order here momentarily. Appreciate everyone being with us. Thank you. All right. So if we could have the appearances of the counsel who are in the courtroom in person. Ms. Allman Road is joining us, as well as others. I believe we have Mr. Dubin. Looks like Mr. Pitts. And who else do we have? And Ms.
Jason Thompson on behalf of the class plaintiffs, Your Honor.
Okay.
Morning, Your Honor. William Kennedy on behalf of the class.
Did the other lawyers decide that you weren't nice enough to be at the table with them, or? Okay. Well, if you would like to join them, please feel free to do so. I assume that Mr. Pitts will scooch over a little bit to give you room, but if not, we'll take a recess and give him the opportunity to do so. So, all right, thank you. Good morning, everyone who is in the courtroom. On behalf of the people is appearing by Zoom. I see Mr. Gamble and Mr. Cool. Is that correct, gentlemen?
Yes, Your Honor. Nathan Gamble and Richard Cole on behalf of the defendants.
Okay, just so long as I am on that, from this point forward, any hearing that the court has, Mr. Gamble and Mr. Cool will be required to, or Mr. Gamble and another counsel for the Attorney General's office will be required to participate in person. I believe it will be helpful for the movement of the case forward. Don't have any problem with them appearing remotely today, but from this point forward, Mr. Gamble and one other counsel for the people will be present. And Ms. Allman Road, who has been endorsed as the polypotenate for discovery and other purposes for the plaintiffs, she'll be required to be in person, as well as at least one other counsel as we move forward in this litigation. On the list, I also see Emily Peacock, Rachel Flanagan, Michael Von Volanta, Theodore Leopold, who's Leslie Kroger, Dana Frazier, Timothy Takala, Elizabeth Fagan, Megan Shannon, Kyle Jacobson, Daniel Pifko, Thomas Wan, Amanda Washburn, Michael Beam, and Kevin Carlson. Did I miss anybody? If so, speak now or forever hold your peace, as they say in the services uniting individuals in the state of matrimony. All right. No one so indicating. Thank you. The court's February 23rd, 2024 scheduling order at page 13, paragraph 7, indicated the protocol for agenda items for status conferences. There were no agenda items submitted pursuant to paragraph 7, page 13 that I am aware of. Ms. Allman Road, are you aware of any agenda items that were submitted other than, and I did receive the indication as far as mediation that the people, that the state defendants had indicated unwillingness to participate in mediation meetings at this time. I received that. Is there anything else? Okay, thank you. Mr. Gamble, Mr. Cool, are you aware of any agenda items having been submitted on behalf of the people, or I'm sorry, old habits are hard to break, on behalf of the state defendants?
Nathan Gamble on behalf of the state defendants. No, Your Honor, we did not submit any agenda items.
All right, fine. I have, I guess, let's see. I have about 8 pages of notes of what I want to go over. And as we're going through things, I'll ask for input, insights, responses where I deem it appropriate, but also I would ask that as we're going through this, if counsel for plaintiffs or counsel for the state defendants, as we proceed through this, these discussions today, if there are other things that these discussions lead to for purposes of that you think we ought to talk about or might be helpful, I'll give you the opportunity to at least suggest that. I'm not sure we will, but I'll, so as we're going along, if you can keep track, that'll be great. And as I think I've done in most of the hearings previously, at some point I'll take a short recess, probably in place, to discuss matters with Ms. Husa, the lawyer for the court, to see if she has any suggestions of things that I need to clear up on the record. I will tell you today, we're going to be talking about Mr. Gamble on a witness list. We're going to be talking about mediation/settlement conference. Talking about discovery. We're going to be talking about the dates for summary disposition motions on class certifications. We're going to be talking about the dates for oral argument on same. We're going to be going over some of the pleadings that Mr. Gamble submitted on January 31st, 2025 for purposes of illustration of what I would like moving forward as far as appendices and suggestions on how we can work together to get to resolution. I'm going to be asking questions about the status of the C7 motions and the allegation of defective pleadings and timing on when to make a decision. We're going to be talking in terms of assuming for purposes of today that summary disposition under 2.116 is denied in favor of either the plaintiffs or the defendants. I'm going to want to know how long the plaintiffs are going to require to try their case, days of trial, and I'm going to want to know how long the defendants are going to require to try their case. For purposes of your reflection and consideration, when we get to that point, you can assume a trial day is going to look like this. It will start at 8:30. It will go until 10 o'clock. There will be a 15-minute recess. It will reconvene at 10:15 and go until noon. There will be a 1-hour lunch recess. We'll reconvene at 1 and go until 2:30. There will be a 15-minute recess mid-afternoon. It will go from 2:45 until 4:30. Parties will not be able to entertain evidentiary objections. The court will not entertain evidentiary objections during trial, which could have been handled by motions in limine ahead of time. I have had the privilege of presiding over, I think, 234 jury trials and 50 courts martial, as well as being judge of record in approximately 10,000 cases. When I say we start at 8:30, I mean 8:30. I don't mean 8:31. I don't mean 8:29. I don't mean 8:35. When I say it's a 15-minute recess, I don't mean 17 minutes. I don't mean 14 minutes. I mean 15. So we will be proceeding in that fashion. So the reason I bring that up is when we have that amount of time on the record, we can cover a lot of testimony and a lot of evidence every day. So we're looking to try to get and obviously there is no way of knowing whether it's going to be, every trial has unanticipated things come up. So when you tell me today, I think it'll take me 5 days. I think it'll take me 10 days. I think it'll take me 17 weeks. If it's the final one, we're going to have some discussions, but I get that these are estimates and that you're not going to be, if you say it's going to take me 8 business days to try my case or 5 business days and it takes you 6, that's fine. But we're not going to be in a situation where we're going to be going, 3 times as long as, we project, because we've got to set trial dates. I have possible trial dates intended for possible 10 days in December. I have 14 days in December 2025. And I have 14. I hear voices or music. So,
Your Honor.
okay, that's what my children normally say. And my beloved grandchildren are not old enough to tell me that. Goomba, you're hearing things. I'm sure when I see their angelic faces and when they look at me, that's probably what they're thinking. But anyway, so no worries. I remember I was representing a client when I was in private practice, and I was right when cell phones had, basically where portable ones had come out. And I am in the 63rd District Court, and I can't, or 61st, I cannot get this thing to turn off. And my good friend, Judge Logan, goes, I don't know whose phone that is, but it either belongs to me or the owner's going to jail. It's like, Your Honor, Mr. Redford, I would expect better on you. Well, I'm sorry, Your Honor. So no worries. Mine does all sorts of things that I don't know. Okay. So that's going to be I've got potentially 14 days in January 2026. And just for purposes of your thought process, I will anticipate the closing arguments in this case, if it goes to trial, these cases will be, and this is, again, we're bifurcated, this is on liability, that it's going to be by written submission. I just think that it will lend itself to a more focused resolution. And in the submissions, the court will expect proposed findings of fact and proposed conclusions of law. We're also going to talk about, as we go through this, other status conference dates between now and a year from yesterday. We'll be setting 4 more status conferences. We may need all of them. We may need more. We may need less. I don't know, but this is what I want to be talking about here today. Now it's 12 minutes after 10. Now let's get into the substantive part of this. The first thing I would observe is there are 87 days until discovery is completed. 87 days until you're done with discovery. And that is an extension of discovery beyond January 31st, which was in the court's order of a year ago that the court granted previously. The parties need to operate under the expectation that there are not going to be any further extensions of discovery. And whether that means, I don't know what it means for the parties. I don't presume to. We've got capable counsel representing both sides. But that jumped out at me yesterday as I spent several hours reading the January 31st pleading of the state defendants. And as I was preparing for today's hearing here, it's there. I'm reminded of an advisory panel that I serve on. We had to provide a comprehensive review of a certain statutory construct to the Congress of the United States by December 31st of this past year. And for the last 18 months, every time we would have a conference call or an in-person meeting, or we would take testimony from experts, the vice chair of our committee, who was in charge, who was the quarterback of this, would say, we have X number of days until we have to be done. We have until this has to be to Congress. We have X number of days until this, and it was, no one felt like we had enough time, but it was a hard deadline. We couldn't get the statute changed. We didn't seek to have the statute changed. The report was submitted in timely fashion. I bring that up only to communicate to counsel both virtually and in person. I understand how disruptive hard deadlines are. I understand that this affects your other cases. It affects your relationship with your companion or significant other or spouse. It affects when you get to walk your dog in the morning. It affects everything. I get it. But that's the line of work that all of us are in. And this is an important case for the defense. It's an important case for all the plaintiffs. We need to move forward. So working together on these 87 days, I think would be most beneficial. Okay. First substantive issue. Mr. Gamble was listed as a likely witness before we had the opportunity to meet together a few weeks ago. Maybe it was just a week ago. I don't know. But anyway, we've met, we've talked. I get the impression that the state defendants have filed some type of notice or an amended answer. Is that correct, Mr. Gamble, Mr. Cool?
Yes, Your
that's
Honor.
correct.
Okay. In the way our case management systems, I did not receive the actual discovery document, but I received the notice of filing. Could someone just summarize it in, a paragraph or less?
Yes, Your Honor, this is Richard Cole for the state parties. We'll summarize it as since the Department of Attorney General has been dismissed from the lawsuits, we have removed any references to Assistant Attorney Generals as potential witnesses in response to those interrogatories.
All right, thank you. Did Mr. Cool appear anywhere else as a prospective or potential witness pardon me, some papers just dropped. In response to any other answers to any written or any discovery?
No, Your Honor, I've just appeared recently in the case.
Mr. Gamble?
No, Your Honor. Mr. Gamble has not appeared. I have not appeared in response to any other
Okay.
discovery request.
All right, thank you. And that was filed what day?
Last Wednesday, Your Honor.
Okay. Have the plaintiffs had an opportunity to review that and to determine whether or not that's going to impact Mr. Gamble's presence on a witness list?
We have.
Okay, what's the situation? Thank you. Oh, and I was just advised by Dan today that apparently we're going to get microphones at our council table here in the near future. So we're going into the 19th century slowly but surely, and hopefully we'll have them before trial.
Hope we're all ready for it.
Yeah, in some ways, yeah, anyway.
Your Honor, Jason Thompson again for the class plaintiffs. So removal of Mr. Gamble obviously solves the bulk of the concern that we had, which was if they call him as a witness, what are we to do? So the only thing I will mention for the court is in the last 6 months, we have found a tremendous amount of material that indicates Mr. Gamble had more than a lawyerly involvement in the case. However, I still stand before you as I did last week or so and tell you that I don't see that Mr. Gamble is going to be called as a witness. Number one, we've already served our initial round of deposition notices. He is not on it. I know what the second round of deposition notices are that we're contemplating. He's not on those. As you mentioned, we have very little time, a long way to go. I don't see that Mr. Gamble is going to be called as a witness. So there's two ways I think we could propose to proceed. I know they want us to strike him as a witness. We could probably do that with your Honor's understanding of what we have submitted to date. If that theme, that concern that we have gets developed further in the depositions that we take, it won't be a surprise if I stand before you and explain why I want to take Mr. Gamble's deposition, understanding that it's going to be a tremendously high hurdle, if even impossible, for all the reasons we've talked about. That's option number one. Option number two is just leave him on the witness list, knowing that we're probably never going to be taking his deposition.
Mhm.
It's a witness list, that's all.
All right, stay at the podium. Either Mr. Gamble or Mr. Cool, on behalf of the state defendants, having heard brother counsel, what are your thoughts?
I think, again, Richard Cole, Your Honor, we would like to have the plaintiffs strike Mr. Gamble from the list at this time. I think their initial proposal would be fine, but until there's some facts developed to indicate that he would be a likely witness, he shouldn't be on there at all.
All right. Okay. Uh, That's my preference as well. So I'd expect that the plaintiffs would do that. It is without prejudice to bring a motion to amend your witness list to add him if necessary. You understand the court's comments previously. So, all right.
Very good, Your Honor.
Okay, thank you. All right. Next one, mediation. Okay, I have been advised through Ms. Allman Road's submission, and thank you, counsel, for providing that to the court ahead of time, that the state does not wish to meet with the mediator that the parties had jointly selected pursuant to the, I think, July something stipulation on it. It was this past year. And that's certainly, the parties have the right to do that. The court also has the authority pursuant to MCR 2.401A, 2.401F, and 1.105 to order parties to attend conferences, and including under 401F settlement conferences. The Honorable Christopher Murray will conduct settlement conference with the parties. The court is going to order that the state, well, let me just, before that, Mr. Gamble or Mr. Kuehl, how many, do you both know the difference? And I'm not being pejorative or disrespectful with this question, and I don't, and if it sounds like I am, I don't mean to be. In the state civil service, my understanding is there are what are called classified employees and unclassified employees. Is that both of your understanding?
Yes, that's my understanding, Your Honor.
Okay, and my understanding is that each department has a finite number of unclassified employees, typically 3, sometimes I think as large as 5. Do you know whether or not that is so, Mr. Gamble or Mr. Kuehl?
I don't have that information, Your Honor. This is Nate Gamble.
Mr. Kuehl, you're shaking your head left to right, which suggests to me that you do not know either.
No, I heard that information, Your Honor.
All right. The reason I make that inquiry is an unclassified employee is a person who serves at the pleasure of the director of the agency and or department with certain limitations and the governor. All my understanding is that all agency or department directors are unclassified. The reason I bring that up and why it is relevant to what we are discussing today is the court is going to require in attendance at the discussions with Judge Murray, and I'm going to direct that Mr. Gamble and Ms. Allman Road are going to be the quarterbacks of contact with Judge Murray's chambers sometime after Wednesday, so I have the chance to at least let him know. He knows this is coming, but he doesn't know it's coming for sure. So I want to let him know that it's coming. I'm going to require either the director of the Department of Environment, Great Lakes, and Energy, and the director of the Department of Natural Resources, or one of their deputies who is in the unclassified status to be present physically together with both Mr. Kuehl and Mr. Gamble on the day that the first settlement conference is had with Judge Murray. I can tell you I have had the privilege of serving as a director of a state agency in the past. I have personally been required by an order of a judge of this court that I currently serve on, that is no longer serving on this court, but is on the Court of Appeals, to attend such a conference when a claim was made, not an inverse condemnation claim, but a claim for damages based on one of the the activities that did or did not take place at one of the state veterans home that were that I was responsible for as the director of the state agency. Why do I say this? Why do I bring this up? To tell you how great a person I am? No, by no means. To tell you that I understand. When I got notice of that, I talked to my lawyers at the state AGs. I said, "Are you kidding me? That guy can't order me to fill in the blanks." And the lawyer said, "Director, I'm pretty sure he can. We can fight it if you want." I said, "No, whatever. Well, I'll go." So I went. It was my duty to try to coordinate the services to 640,000 veterans of the 10 million citizens of this state at that time. I had a busy schedule. I had a lot of other things going on. I get that requiring the director of Eagle or the director of DNR to attend a settlement conference is a major inconvenience and a major difficulty, as it was for me when I was the director of a state agency. Much to my surprise, the case I was required to go to settled. My point is, if we do not have the principals in the room discussing back and forth, the likelihood of resolution is non-existent. This is why the court is going to include this as part of my order. And I want, in the event that the state defendants choose to file an interlocutory appeal to this order, which will be issued eventually after this conference, I want the reviewing panel of the Court of Appeals, and to the extent the Supreme Court is asked to review it, to understand I am making this decision based on having presided over the 10,000 cases I did, the 230 jury trials, and the literally hundreds upon hundreds of settlement conferences I presided over as a circuit judge, as well as 17 years as a litigator for the Department of Justice, one of the largest law firms of the state of Michigan, and as a Navy judge advocate. I get this is a major problem and an inconvenience, not problem, but an inconvenience for the parties. I am doing so because I believe under MCR 1.105 and 2.401F, this is the most appropriate way to proceed. It may not resolve the case, and then fine. But I think there is a real possibility it could. Otherwise, I wouldn't be ordering this. So we'll be proceeding with that. I'll draft an order. It'll get out probably the middle of next week would be my guess. And it's not going to set a date. It's not going to set a time. And the plaintiffs will be required to have named proposed class representatives physically present at the mediation as well. And again, it will be conducted by Judge Murray at a date, time, and place that he may order. And if he requires counsel to provide him any summations or anything, he'll advise you of that. All right, Mr. Gamble, you're the parties that objected to mediation. I'll give you the opportunity to be heard before we move on to our next subject on this issue.
Your Honor, just a clarification. You had said it would be either the director or an unclassified deputy. Is that right, Your Honor?
Yes, and what I'm getting at is I don't know how that department, these two departments work. I apologize. I have nothing but respect for. I know the director of the DNR. He happens to be a friend. He's a Grand Rapids lawyer. We've run in the same circles for decades. He's a former judge, as all of you know, former director of the state lottery. Now he has the privilege of serving as the director of the DNR. So I don't know the director of Eagle, but my point is, Mr. Gamble, I don't, with no disrespect to some high level career person, this is we need somebody at a very high level of responsibility and authority. There's no question that if everybody went in the same room and we said, okay, we agree, we're going to settle for $10 and we're going to pay it on this, and this is, and you come up to all these terms, it still has to be approved. If there's an expenditure of more than a certain amount of money, it has to be approved by the state contract board. And I know I'm getting the name wrong, the state administrative board. It has to be approved by the director of the agency or the department. I mean, there are multiple steps. There may be legislation that needs to be taken into consideration if it's a transfer of resources from a public source. So my point of all that is I need for something to be meaningful to have somebody at the highest level. When I initially was going through this, I will be candid to all the parties and to the reviewing tribunals that'll determine whether or not I'm abusing my discretion here. I had initially intended to require the directors of these two state departments to be there. I believe that is overreaching on my part, and I have pushed it back. And so, but it needs to be someone who is at a very high level. And maybe some of the people who are already on the witness list would be there. Maybe the director of dam safety is the person. I don't know. If you think whatever level I have marked it at is incorrect, I'm willing to listen for suggestions. If you get it and you say, Judge, you're so far off the mark on this, you probably don't want to put that in your written submission, but you can submit a request, for immediate consideration to change the identity of individuals who will participate. And it's not like, I'm not going to make you do this next week. I anticipate this is not going to be until the middle of April that you're meeting. Okay, so we have time to work through some of the details, and I'm happy to do it on a conference call with Mr. Gamble and Mr. Cool and Ms. Almanrode and one of the other attorneys for the plaintiffs, where we just work, okay, you guys come up with where you're close, and let's get the final parts over the finish line to set up a process that's going to be meaningful and definitive one way or the other. So that's a very long-winded and disjointed answer to a finite question. But that's where that's my answer. Does that answer your question, Mr. Gamble?
It does, because I was going to mention, Your Honor, that neither Mr. Cole or I know exactly how the leadership is organized, either
Right.
or DNR. So once we meet with them, it very well may be we can satisfy the court's initial order, but if there does need to be an adjustment, we'll of course bring it to the courts and the plaintiff's attention and work with the court to get the appropriate person there present. We understand the court's direction.
Right. Okay. Thank you, Mr.
And Your
Cole.
Honor, Richard Cole, I would add to Mr. Gamble's comments that we are always open to discussing resolution, and we have advised plaintiffs of that multiple times. Our concern about mediation in front of Judge Rosen is he didn't believe that there was any further possibility of making progress. But it's fine. We're happy to go back again. But in looking at trying to get to resolution, it has to be a two-way street. And to date, we haven't even received a settlement demand.
You're taking words right out of my lips. And again, I was thinking in terms of, I'm going to make the darn directors show up, and by God, I'm going to make them each submit these 10-page settlement brochures and blah, 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 blah. I agree, Mr. Cool. One thing we need to know, and I don't need to know, I obviously don't want to know it. And I don't know that as an initial foray, even plaintiffs have to say, we need X. And X can be $10,000 or X can be $200 million or whatever number, greater, lower, or in between. And X may be, we need this remediation. X may be all sorts of things. Mr. Gamble, it's a matter of record. He puts it in his January 31st submission. There's been $200 million spent, at least according to the representation of Mr. Gamble, on remediation and all that. Where does that factor in, if at all? I don't know. But I think the plaintiffs have got to say, whatever day it is that you meet with Judge Murray, who I think is maybe one of the finest individuals I've ever known in my life, and I know him to be one of the finest judges I've ever known. So we've got a fair, even-handed, cool-tempered, level-headed person. When you're done with him at settlement, you'll wish he was your trial judge. I understand that, but I can live with that. But you need to, plaintiffs have got to have, what is success? And then let's, what I always would say to parties coming in a settlement conference, my goal is to make everyone unhappy today, because that means there's been compromise. So I'm not going to get into the settlement part of it, but I agree, Mr. Cool, completely. The state needs to know what the plaintiffs are seeking to try to figure out, is there something short of a verdict that could reach that goal? And it's entirely possible there's not, but I'd like to know one way or the other.
Your Honor, I would just ask, you're right. I mean, I think you understand that ordering directors or high-level employees is always a significant step. And if we have to bring, we're certainly going to bring them. But if we're going to bring them, we want progress to be made. And we can't make progress without having a demand. So if you're going to order them to appear, I'd also ask that perhaps your order include the fact that plaintiffs have to make a demand, and not the day of, but before, so we have time to consider it. So we have time to formulate a response. So if we're going to this conference with Judge Murray, who I agree is an outstanding choice, that we're coming there in an attempt to make progress, and we can't do that under the current status.
Solomon Road. And could you come to the podium so those who are joining us via the internet are able to hear us? And for lawyers who are and the persons watching who are present online, we do hope to have microphones soon here in the Court of Appeals courtroom. So, ma'am.
Okay, first up, plaintiffs have always been interested in mediation.
Right.
And we certainly welcome the settlement conference as an alternative. And we have a different interpretation of what went on with Judge Rosen. And I believe that Judge Rosen would have a different interpretation. He was prepared to continue mediating this case.
I don't doubt that he was. I don't. I have.
And-
Judge Rosen's a legend. He's got a book. I mean, I don't have any books, Murray doesn't have any books, but I mean, Judge Rosen is the gold standard. And but it didn't work out, and that's okay. I mean, but there's a movie that talks about where somebody gets hit in the head, and then somebody says, "Why'd you do that?" And then this character in the movie says, "It doesn't matter." And the person who got hit in the head says, "Well, why?" He goes, "It's in the past. I can't change the past." Okay. I know that it didn't work. I know that the state doesn't want to go forward right now. And that's fine. They have that right, just as you have that right. What do you think about what we're talking about going forward?
The plaintiffs welcome any opportunity to engage.
What about the willingness to make a comprehensive demand, let's say a week to 10 days before it's scheduled?
We will have demands from mass torts, and I believe, speaking for Mr. Dubin, they will have one for class as well.
All right. Okay. And I guess what I would say is, thank you. Okay, good.
Okay.
Appreciate it. Success can look so many different ways for so many different folks. And I would encourage creative thinking in how do we get to where we need to be. And I'll leave it to y'all to do that. Okay. Anything else then from Mr. Gamble or Mr. Cool?
No, Your Honor. Thank you.
All right. Let me just take some quick notes. All right. Thank you. All right, that's page 1 of my 8 pages. Good, we're moving along swimmingly. All right. Okay, let's talk about assuming for purposes of the discussions from this point forward that the case is not dismissed as a result of the January 31st, 2025 pleading. I am not ruling. I am not making a judgment. I'm not commenting. But I just want to, we need to establish our port and starboard running lights, as we would used to say in the Navy, so that we don't hit the rocks and shoals. So I want to get dates on the calendar because we got a bunch of very busy lawyers here. So as I look at the case management order as amended, the next discovery ends May 1st, 2025. We have a filing deadline of July 3rd, 2025 for SD motions and for class certification. The responses are due on August 7th, 2025, and reply briefs are due August 28th, 2025. In the most recent submission, Mr. Gamble's pleading was a little bit over the 45 pages that was indicated in my original February 23rd, 2024 pleading, but I had articulated in my written order in December that I was going to be flexible. So I'm flexible. I'm not worried about it on that one. For everybody's information, you cannot exceed the page limit this next round. Okay. I need help to try to get through this. So, no quarrel with what was submitted, last week, but, moving forward, we need a little more help. Okay. So those are the dates. Oral argument on those motions for summary disposition and class certification will be at 9:00 a.m. Monday, September 15th, 2025 in this courtroom. I want to draw everyone's attention, and I wish everybody was here today, but they're not. Okay, I need to have an exemplar. Okay. Had one. So somebody, Mr. Cool, Mr. Gamble, after we're done with our hearing today, I'll have one of my staff scan and PDF what I'm handing out right now. It's pretty simple, but I obviously don't have the capacity to send it to you right now. Somebody plans to come up. All right, what I'm handing counsel is the table of exhibits from Mr. Gamble's submission on January 31st, 2025. And in the table of exhibits, and I don't want to sound critical because I'd never said, here's how I want you to do it. I'm telling you how I need you to do it now. Okay, right now we have 2 columns and it says Exhibit 1, and then the first one is IFT report, Exhibit 2, Trumbull affidavit, et cetera. All right. Here's the problem. So yesterday when I'm reading through this, the PDF version that I have access to is 1,157 pages. All right. And that's fine. Kind of long, but it's fine. The problem is when we catalog our exhibits this way, then I have to scroll through, or my law clerks have to scroll through to where the exhibits are. And it took me 5 minutes or so to find, for example, it was, not Mueller transcript. Oh, geez, too many, I got too many pages. It takes too much time. So what I need the parties to do, and Mr. Gamble, and I don't need this done today, but sometime like by the middle of next week, I would like another exhibit or a submission. And in it, I want to add another column. And if you're going to see it, Mr. Cool, Mr. Gamble, when you get it, it'll be exhibit number, description, and then pages of the PDF. So the lawyers that work with the court and I are going to need to be able to go to the table of exhibits and then to see, oh, okay, the thing that I'm looking for is at, page whatever of the PDF. By way of example, yesterday I was looking for yeah, jeez. One of the transcripts. Okay. The transcript of Mr. Sturtevant. And it took some amount of time scrolling through to find exhibit 45. So I needed to do that. So and here's how, ideally, when you submit it to the court, it would be there. If for whatever reason, when you all are submitting your things, it's just not possible to do that on exhibits, to tell me what the PDF pages are, that is fine. Submit away. But then the next day or simultaneous with, you've got to go back and create another table for me that tells me where are these exhibits. Okay, there's just too many documents and too many pages for me to be able to get through everything in any type of logical fashion. Okay. Mr. Gamble, any objection to that additional requirement being placed upon your clients and you?
No, Your Honor, this is Nathan Gamble. And can I suggest that maybe we just do this the same way that appendices are managed in the Court of Appeals, where we use bait stamps? Would that
I would
be?
love it. I would love it. That's something, I'm an old dog and old dogs are hard to learn new tricks. So yeah, I mean, so I have case call tomorrow in Lansing on Tuesday, Wednesday this week, bunch of cases, have the privilege of serving with two great judges, great lawyers appearing in front of us. But some of the courts that we get the electronic records from, some of them you open up the document and then you hit the thing in the table of contents and it takes you right to it. I don't know that that's how these ones are required. And I do know that Chief Judge Schwartzel of the Court of Claims and Chief Judge Godola are going through a lot of steps to get us a new system of case management. Okay, so the next big class action lawsuit probably will not have to deal with this. But for right now, that's how we have to deal with it. Mr. Gamble, however you choose to do it, work with Ms. Almanroad, see what you two can come up with. I just need, when I've got something that has 1,100 pages, I got to know where to look for each exhibit. Okay. I don't need a hyperlink. I just need to be able to go to it.
Oh, I understand completely, Your Honor. So here's my suggestion, and what we can do is we can go through and create an appendix the same way we would in the Court of Appeals, which will have a bait stamp. And then we can update our brief. And so the citations within the brief, instead of to like a page of the deposition transcript, are just to the bait stamp. So you can just flip right to the bait stamp.
That will be helpful, but I also need in the table of contents to know what page it's at. Because
Okay.
for example, if I'm working either at my home office or working remotely with the iPad, I only have one screen. If I have two screens, what you're proposing is great because I've got the brief up on one and I've got the document in support thereof on the other. But because my state of nature is not always two screens in front of me, I think that's great and I would value it and appreciate it. But I also need this old school 65-year-old table of contents. I just need something that I can look to say, okay, then I need to go to page whatever. Okay.
So if we were filing in the Court of Appeals, that's what our table would have. It would have the exhibit description, and then it would have a page number direction to the Bates stamp. Is that what you're referring to, Your Honor?
That's great. That's exactly what I'm referring to. That would be-
We're happy to do that. And what we can do as well, as I suggested, is that we can, and federal appellate courts do this occasionally, where they require you to refile your brief. It's substantively identical, but all the citations have been updated. And so what we can do is we can update our brief. None of the substance will change, but we can change the citations
Elizabeth,
so that it's easier for the court to.
that'd be helpful. Okay. Our legal counsel says that that would be helpful. So it would be helpful for me, but I don't want to, so that would be great. That I would be so appreciative.
Yeah, we obviously want to make it as easy as possible for the court and the staff. And so we're happy to do that. And for the plaintiff's benefit, like I said, we won't change the substance at all. It will just be updating the citations.
Okay, thank you. All right. The next thing about the, did plaintiffs want to be heard on that at all? All right. All right, negative response from plaintiffs. Okay. I want to turn our attention to Exhibit 45 of Mr. Gamble's submission of last week. This is the transcript of Mr. Sturdivant. Okay, the reason I bring this up, there are a couple of things. One, well, I'll just tell you what I used to say when I was a circuit judge. If a transcript of a deposition is important enough, or sections of it are important enough to attach as an exhibit, then they are important enough for you to highlight on each page where it is you think I should be looking, so long as you are providing an identical copy to opposing counsel. And I probably sound like I'm very lazy, and maybe inherently I am, but it's just, there are so particular, and I'm not asking to highlight the interagency task force report or other things, but particularly when it comes to deposition transcripts, I found that so very helpful when the trial lawyers would, especially the C6, 7, 8, not 6, C7, 8, and 10 motions, it was invaluable to help me when I went through those. You're not required to do it. I'm not making anybody do it, but I would just put it out there that as a trial judge, I found that very helpful in my previous life. And my guess is I would probably find it helpful in this life. The only other observation, and I even hesitate to bring it up, but in Exhibit 45, it's part of it's a partial, it's selections of the transcript, but I don't have the entire transcript. And I'm always a little nervous when I don't have the entire transcript of something. And I am not saying, and I'm not ordering, everybody has to provide the entire transcript of, all the witnesses. Please don't do that. But there may be some that, when you talk with opposing counsel, you all agree the testimony of Jim Redford about this one issue is going to be essential. And maybe you do a joint submission to the court. Hey, here's the full transcript, don't highlight it, but the full transcript from these 4 experts that we think eventually, Judge, you're going to have to read. I don't know. I'm not telling you need to do it, but I'm putting it out there. And I get that there are you doing discovery depositions, or are these DeBene assay depositions? All right. Anyway, so that's the observation on 45 in the transcripts. Mr. Gamble or Mr. Cool, do you wish to be heard or to provide any counsel or comment on that?
Your Honor, this is Nathan Gamble. No, just that, gosh, I thought it was either a local or the regular court rules that direct against attaching full transcripts just because they get so enormous.
Right.
But if,
And I don't want them attached to the brief, but I guess there is gonna be that singular witness that if you were opposing, in fairness, you would want the court to have access to the entire transcript, or if you're in favor of, you know that you're gonna want the whole thing. I just, there may be times that it's appropriate to file the whole thing, is all I'm saying.
so, oh, okay. I mean, do you want us, Your Honor, to file the full transcript when we update our exhibits?
No, because I want you to think about it. I don't know that you guys are the trial attorneys and gals, that you lawyers are the counsel. I'm not. I don't want to tell you how to try the case, but I can just tell you that having done these C-2116 motions so many times, and the Rule 56s when I was in private practice, or 12B6s when I represented the Navy, sometimes you just gotta swallow hard and put the whole thing in there, as far as the transcript is concerned. I mean, it's just a long, complex addition to the record. So I'm going to leave it to your judgment on when to do it. Counsel, what you,
So we get the microphones. Jason Thompson again for the class plaintiffs. Looking back at a trial situation, typically what would happen is the deposition would be used to impeach a witness. If for some reason it's revealed or used, then the opposing party, of course, then has the right to go back to that transcript, and the jury's given the rest of the information, so to speak, which it sounds like what you're getting at here.
right.
So if we're not going to attach the whole transcript in as a moving party, it would seem like the option to solve your concern is the responding party
That's okay.
is going to bring back the rest of the transcript and say, well, he didn't tell you about X, Y, and Z, and you better read this.
Right. Okay. Mr. Gamble, what are your thoughts on that observation?
Well, that my initial thought as well, which is that the defendant, or excuse me, the plaintiffs have not yet responded to the motion. Presumably, they'll attach whichever provisions of Mr. Sherdevin's
Okay. All right. Then let's not change any. I'm not going to issue any orders related to this. You guys and gals, you men and women, try your case as you believe appropriate. If you think that you need to include more or all of a transcript from beyond what was provided by sister or brother counsel, then in your responsive pleading, you have the ability to do that. Let's just leave it at that. Okay. Thank you. All right. So, all right. This leads me to then a question about our pending C7 motions. Since we started the process, and this is for, I'm going to inartfully state what, they are, sort of the defective notice plaintiffs, the alleged defective notice plaintiffs. When we began this portion of our journey, it was before I bifurcated. What are the thoughts of the parties since we have bifurcated the case? Should the court move forward and rule on this issue involved in these pleadings, or would it be more advantageous to simply wait until after we finish the liability aspect? Mr. Gamble, you're the moving party, and I don't need a whole oral argument on why you should win, just on but what are your thoughts? I'm going back and forth on this.
Your Honor, the way the law is written, it requires compliance with the Court of Claims Act, essentially regardless of the type of of relief that a person is asking for. And so, even though, I apologize, I haven't had a chance to think about this.
It didn't give you notice on it, so you don't have to apologize.
When we initially filed a C10 motion last year, at the end of August, beginning of September, we had initially suggested that the court could wait to rule on the C7 motion until ruling on the C10 motion.
Mhm.
And so, yeah, our view is still consistent, I think, with that. I think if the court wanted to wait and rule on the C10 motion first, it could. And so I don't know if that's helpful to the court or not.
No, it's very helpful. Anyone from the plaintiffs want to be heard?
Your Honor, Kevin Carlson for the plaintiffs. We agree. We think that the merits and the substantive part of the case are the main event here. And the question of which specific plaintiffs are in and which are out for Court of Claims compliance purposes can be a matter of housekeeping after the substantive and merits issues are resolved.
So are you suggesting, Mr. Carlson, to decide after the C10 is decided, or to, assuming the C10 is denied to the state defendants? And I haven't made a decision one way or the other, so I'm not trying to telegraph anything, but just for for scheduling, would you say then the court should decide the C7 or wait to decide the C7 until after the trial?
Either after the trial or at a minimum after the C10, but even more appropriately after the trial.
All right. Okay.
Yeah,
Thank
I mean, we have
you.
as you noted earlier, Your Honor, we have less than 90 days left. It's all hands on deck for factual discovery and
Right.
briefing on a pretty robust C10 motion, and that and combined with possible facilitation with Judge Murray means our energies are better focused on things that might actually get the case resolved.
Okay. Thank you. Mr. Gamble or Mr. Cool, any follow on after Mr. Carlson's thoughtful comments?
Your Honor, this is Nathan Gamble. My thought is just that if the court denies the C10 motion, I think it would make sense to move to the C7 motion, but whether the court waits before the trial or after the trial, I think it's frankly up to the court. And so
Okay.
we don't have a strong position on that.
All right. Thank you both. Thank you all, counsel. Samara, did you want to be heard as well? Okay. All right. Ms. Holman Road has ceded the podium for purposes of response to that last one. All right. We're now on page 5. This is where my notes talk about trials, trial on liability. What is the estimate of how long it would require the plaintiffs would need to put their case in? On the case in chief, then defense case in chief, and then rebuttal, if any.
Several trial lawyers sitting right here, and none of us have an answer for you at this time. Chance to go through it. Obviously, we're doing that here at the status conference today, but unless one of my brother or sisters has a great answer, I think we're going to need a little time to give you a good estimate. We could throw out 2 weeks, but I have no idea if that's going to be too long or too short. You don't know what witnesses we're really going to boil down to, so it's hard to say. I think I'm spending with you. I would say 2 weeks would be extensive in your estimation. So I think we'll try to shorten it to that period, but that would be the words that would come off my tongue if I were forced to say it right now.
Mr. Thompson, I don't have any idea what you might mean. But... Okay. All right. Mr. Gamble and Mr. Cool.
Your Honor, I think 2 weeks is actually probably about right for us. Although based on the explanation the court provided about how you run trials, and it might be less than 2 weeks, but we would just want to be, we would rather overestimate than underestimate for planning purposes.
Right. Under promise, over deliver. It's good for sales. It's good for lawyering too. All right. So it sounds to me that neither side thinks that we could get this to me as a fact finder in 10 days for both sides. Is that a fair reading of the tea leaves, Mr. Thompson? Do you agree with that, Mr. Campbell?
I think that's probably correct, Your Honor.
All right. So here's if we're having oral argument on September 15th, 2025 on the summary dispositions and the class certification issues, I would be very surprised if I tried to rule from the bench, given the magnitude of this case for all the parties who are involved. So 2 to 4 weeks would be my expectation of when it would take to get that resolved. And have you all an opinion in order on that by the middle part of October would be my expectation. Right now, I have a couple of options. I've got December 8th through the 19th would give us 10 trial days. It's possible I can put together 14 trial days in a row in January, starting on the 12th. While I really would like to get this tried sooner, I also understand it, and I know we could start and then take a month recess, and I never did it with juries, and I rarely had bench trials on my criminal cases. I really don't want to be doing that if I can avoid it. You're going to have to submit trial briefs. You're going to have to submit exhibits. You're going to have to undertake the process of seeing what you can stipulate to. You're going to have to determine all sorts of things. I am inclined to not try to set it in December and rather just 12 January, we're starting and we're going until we're done. Mr. Thompson?
There's a lot to consider, but I want to turn the court's attention to class notice and the opt-out period.
Please.
So roughly speaking, if Your Honor were to take 4 weeks to decide the class cert motion and grant it, the parties would then need some time to discuss what the contents of the notice were and getting notice ready with with a notice administrator. If we took a month for that, that would take you to November 15th. If we had a 90-day notice period in order to allow for opt-outs, that would take you to February 15th. If we had a 60-day notice period, it would take you to January 15th. We're right in that area that you're discussing with January 12th.
Why would it? Okay,
So
I'm listening.
One option is to coordinate the trial date sufficiently out into 2025, and maybe it's January 12th.
2026.
26, sorry. So that we complete notice. Second option would be, since this is just liability, to have the state stipulate to class certification.
Right.
And that would accelerate our ability to get through the notice period.
Mr. Gamble and Mr. Kuehl, any thoughts based on either the court's or Mr. Thompson's comments?
I know Mr. Cole will probably have some thoughts, and I think I'll pass it to him.
Yeah, I don't think we're prepared right now to stipulate to class certification, Your Honor.
Do you think you might be in the future? He said he does not think he is at this point ready to stipulate the class certification. Is that a fair statement, Mr. Cool?
Yes, agreed.
So the question, without binding you, obviously, is
I sincerely doubt if we will be in a position
All right.
to do that, Your Honor. And the timing, just going back to the timing, so much of it is going to depend upon what your ruling is. Obviously, we think we're going to win and it'll obviate the need for a trial, but under the assumption, the possible assumption that you don't grant our motions in full, it's certainly going to limit, I would think, what the scope is going to be. And that's probably the problem right now, is that the potential scope of the trial that the plaintiffs have put together is so significant, it makes it hard for us to limit the number of days. But I suspect once we get closer to that trial, the days are going to narrow significantly as to how much time is going to be needed for trial.
yes. Mr. Cool, council wants to have a discussion among themselves. How long do you, how much you need, how much time? Okay, fine. All right, we'll stay on the record. And while councils, even though we don't have microphones, they're going away. Okay, all right, we're off the record, but in place. So if everybody who's on the Zoom can just stay with us, and if our court reporter could stay with us, thank you, Ms. Price, for being here. And then I'm going to talk with Ms. Husa offline as well, counsel for the court. Thank you. We'll be back in a minute or two.
I'm sorry to interrupt, Your Honor. But
Yes, ma'am.
I was just wondering, this is Megan, the court reporter. I'm sorry to bother you. But if I may just have, request the counsel that's in your courtroom to just state their names again. I'm sorry, I didn't hear them. And just whenever's good.
No, we'll do it right when they're still scrumming now, but once they break and are ready for the line again. Okay, I need a cue of all my great lawyers in the courtroom, and you're going to identify yourself, okay? Everybody, please follow Mr. Thompson.
Jason Thompson appearing on behalf of the class plaintiffs, Your Honor.
Thank you.
David Dubin on behalf of the class plaintiffs.
Thank you.
Sharon Almonroad on behalf of the mass tort plaintiffs.
Thank you.
Paulina Kennedy on behalf of the class plaintiffs.
Thank you.
Michael Pitt for mass tort plaintiffs.
All right. Is that satisfactory, Ms. Price?
I'm sorry, and it was just sister counsel. It broke up on my end. I'm sorry if I may have the last.
Can you hear me now?
Yes, sorry.
Paulina Kennedy on behalf of the class plaintiffs.
Thank you.
Thank you.
Okay. Did you need Ms. Almonroad as well?
Nope, I have her. Thank you so much. Sorry to bother you.
No, it's not. No, thank you for making a record. All right. We're continuing on the record. Mr. Gamble's with us. Mr. Cool's with us. I see three, and Ms. Price is with us. I don't see any other individuals. I don't know what that means, but continuing on.
Thank you very much, Your Honor.
You bet.
We have had a chance to scrum, as you say, and discuss keeping the January 12th
Yes.
trial date that you want us to talk about today. And I believe there's several adjustments that we could propose that would accommodate the notice problem. One is if we go to a 45-day notice period instead of a 60-day notice period, that will pick up 2 weeks. A second is rather than having 30 days baked into the schedule for plaintiffs and the state to negotiate the form and content of the class notice, we squeeze that down to 2 weeks and pick up another 2 weeks.
Oh, and the court can get 2 more weeks by making a decision quicker. So instead of 30 days for me, I cut it back to 15 days.
That's correct.
Parentheses, read the lawyers who help support me are going to be working so hard, and I feel badly, but they're brilliant, and I know they work hard and they're very capable. So those 3 things, that's 2 months.
Month
Almost.
and a half, I think, but
Month
yeah.
and a half. See, that's why I had to get out of private practice. I couldn't work by.
I do
yeah.
threes really good as a plaintiff's lawyer. Three
I used to
periods.
be able to.
We may even want to consider, as we move this discussion forward, adjusting the hearing date or the filing date of the class cert motion to stagger that somewhat with the C10 motion, but perhaps that won't be needed. My point in all this is I think we're confident as a group that we can make some adjustments as long as the court doesn't see a problem or the state doesn't see a problem with the items that we've identified. I think it's safe to say we can progress in today's discussion and proceed with that January 12th date.
Okay, thank you. Mr. Gamble or Mr. Kuehl, any thoughts?
No, I thought the plaintiffs' counsel made some good points. This kind of came out of the blue at us today, and perhaps at our next status conference, we'll have time to have considered this a little bit further and can make some more informed decisions on this issue. That would be my only suggestion, Your Honor.
Okay, thank you. Mr. Gamble?
No, nothing further from me, Your Honor. Thank you.
Right. Okay. There's one of our other lawyers. It's not present. I just got a text. I just want to see. Okay. It's not about the case. All right. I think that parties need to plan for a trial that is going to begin January 12th, 2026. And that will work other things around. Right now, I intend to block out on my calendar the 12th through the 16th of January, the 20th through the 23rd of January, and the 26th through the 30th of January. That will give us 14 full trial days. This is going to be memorialized in the order that we're going to be issuing after this hearing. And again, because I have case call tomorrow and Wednesday, it's not going to, it might be next week. But and I'm not doing this to be punitive or to, rattle anybody's cage, but we've got a lot of folks who are involved and we need to lock in some trial dates. And even it's a year from now, but that's going to come up, 330 days from now or 345 days from now. So I appreciate Mr. Cool, what you said, and Mr. Gamble and Mr. Thompson and everybody, but we got to get this thing locked in on a trial date. And I need to work around availability of the courtroom if we're going to do it in a court of appeals courtroom from case call. So that's I would anticipate blocking that out on your calendars would be a helpful thing for planning purposes. And I recognize there are going to be vacations that are going to be canceled. They're going to be anniversary trips that you're not going to be able to attend. And I recognize there are a whole bunch of things I'm not going to be able to do that I would normally do in January each year for most of my life. But we need to get this done. Okay. Other dates I want council to take notes. If you could get out a pen and pencil to write these dates down. This is for the continuing status conferences. They will be on the following dates. Monday, May 5th, 2025. Monday, August 11th, 2025. Thursday, August 6th, 2025. And for now, we're going to put on the calendar Monday, February 2nd, 2026. We may either be in or completing the trial by then, but I want to have those dates blocked in. Council.
Your Honor, you referenced August 6th.
No, I said, if I did, I misspoke. I meant to say 11 August and 6 November.
November 6th is correct, right? Sorry.
Right. No, what was the problem?
You said August twice.
You said August twice, August 11th and then August 6th.
That's why we've got all these great lawyers.
Well, I mean, I would love.
I can't even read a calendar. I mean,
Particularly go back in time. We're gonna come on the 11th and then come again on the 6th.
I mean, I enjoy coming here, Your Honor, but
well, I'm glad you do, counsel. And the court very much enjoys having all the lawyers, very capable advocates that are.
Your Honor, this
Sorry,
is-
said the court enjoys the very capable advocates who are here and have been here. I'm trying to bring up a calendar. All right. I'm guessing it'll be 10 o'clock or 9 o'clock. We'll sort it out. Is there a time during the day? I don't know that any counts. There might be a couple that are Grand Rapids. I mean, is there a preference from Mr. Cool or Mr. Gamble for time of day to have the conferences, status conferences? The world is your oyster.
Your Honor, this is Nathan Gamble. If the 10 a.m. time works for the court, that would be our preference earlier in the day.
Plaintiffs?
Ten AM is signed for plaintiffs.
Thank you. Then we'll do it at 1. No, I'm just kidding. 10 o'clock a.m. is what we will do. And that's what will be included in our orders. Okay. That is the end of page 8 of my handwritten notes for today. Ms. Almonroe, the plaintiffs have the burden of proof. You may welcome anything else you want to address. Any objections, corrections, notices that you're immediately appealing, anything, just so we can have our schedule.
Earlier
Pardon?
Earlier, you mentioned that you wanted the briefs to be limited to 20 pages going forward. That you wanted briefing to be limited to 20 pages.
No, I don't. If I said that, I misspoke and I apologize. I'm so glad you're bringing that up. I would not expect anybody to be able to brief these C10 issues, C2116 motions, 45 pages. That's what the order, that's what my initial scheduling order was. And that's what I would continue to ascribe to.
I believe Mr. Gamble's now, I don't know if that includes like a cover page or something, is 54 pages.
Right. He noted in footnote, I'm not sure what, the court's order, you have that many pages. However many he had, you can have. But my friends and very highly valued professional colleagues whom I respect so much, from this point forward, we're keeping it at 45 pages. Okay? Smiles? No smiles, just nodding of heads. Okay.
Thank you.
Anything else?
Nothing else.
All right. Any plaintiffs' counsel who are appearing remotely wish to be heard? All right. No one so indicating. Mr. Gamble or Mr. Cool, we've been here together since 10 o'clock. Anything that either of you would like to place on the record? Any objections, any corrections, anything else that you wish us to address before we recess for the day? Mr. Gamble?
No, Your Honor. Thank you.
Thank you. Mr. Cool?
No, Your Honor. Thank you for your time today.
All right. Counsel, thank you all very much. Time is now 11:29. This completes our hearing for today. I appreciate everyone's patience with the court as I seek to work through this process with each of you and try to get the matter resolved in the trial court level. So thank you. 11:29. Ms. Price, anything else we need to address before we go into recess?
No, thank you so much.
No, thank you, ma'am. I appreciate so much your assistance and your professionalism helping us out. Court is now, Elizabeth, anything else? All right, court is in recess. Thank you. Have a nice day, everybody. You're welcome. Thanks. Please go about your business.